Welcome to Legal Resources Radio, where we invite you into the world of social justice, advocacy, and public interest law. Throughout this podcast series, we'll share stories, insights, and expert advice from our dedicated team at the Legal Resources Centre, as well as from our valued guests. In each episode, we'll dive into the legal landscape, tackle pressing social issues, and aim to empower you with the knowledge to make a difference. Whether you're a community activist, a legal professional, passionate about social justice, or just curious, this is the place for you. So wherever you are, washing dishes, at work, on the bus, train, or plane, or just relaxing at home, plug in your headphones, take a deep breath, and get ready to begin.
Welcome back to the Legal Resources Radio. Today we're going to be talking about a very controversial topic that's hit our news outlets, but also international news outlets. On the 24th of January 2025, President Cyril Ramaphosa signed the Expropriation Bill into law. It hasn't quite come into force, but he has signed it. The Now Act, it gives the state the power to acquire property rights from owners for the express purpose of using it in the public interest or for public purpose. The ambit of the Act is in line with Section 25 of the Constitution and merely realizes the intentions of the Constitutional's drafters. It expressly provides that property may not be expropriated arbitrarily or for a purpose other than in the public's interest or for a public purpose, as I said. It is important to note here that the power is very similar to what most governments across the world have at their disposal, including the United States of America, who come up quite a lot in this debacle about expropriation in our Act and our government's actions. Yet the moment the Act was signed by the president, South African government came under a hell of fire. Agents within our country, in particular the Organization of AfriForum and Solidarity Movement, propped up by the President of the United States of America, Donald Trump, implemented a disinformation campaign, and it spread like wildfire. It was the most controversial and spoke about topic in the news at the early stages of 2025. And as a result of this, I think a lot of people in South Africa are in a big fight about what this act does and what it means for landowners in South Africa. And it's being a topic that we've been speaking about at the Legal Resources Centre quite a bit. And so today I've invited my colleague Cecile van Schalkwyk, an attorney from the Mkanda office of the LRC, and she's an incredible attorney who's stationed all across the country working on many cases, including education, but more importantly, land cases. And so I'm very excited to be joined by her to be doing some very light myth busting on this topic. I hope you enjoy it. Cecile, good morning. Hello.
Good morning. Hi.
Thank you for coming here. So I insisted, obviously, that we speak in person. So I very rudely, got you up late yesterday, I suppose, and then you flew in, and I think it was quite late, and you had a hectic, reintroduction to your family. So how are you? Are we doing well? Have you had your coffee?
I'm fine. I've braved the Cape Town traffic, but I've survived it. So I'm okay. I think apart from the traffic, Cape Town is as joyous as it always was.
Well, thank you for coming. I think there isn't really anyone better to do this with. Just off the top, I mentioned a little bit earlier that what this act does and why it was drafted. But since you're so much more intelligent than I am, and you have more expertise in this field, rather, let's say, can you just kind of give us a brief overview of what this act does and maybe explain the intention behind its drafting to us?
Sure. So, the concept of expropriation is actually a concept that we see in most governments across the world, because very often the state has to expropriate private land for public purposes, right? So, for example, historically, it's been used, for example, for the building of a dam. Let's say, somebody owns a piece of land and you've got to build a dam on that piece of land because it is in the public. The public has to benefit from that. That's what expropriation has historically been used for. Now, in South Africa, the last act that we had that actually dealt with expropriation and set out the procedures and the purpose of it, was a 1975 Act. Now, we know obviously that since 1975, we've had a democratic constitution that has come into force.
Quite a lot has happened since then.
Quite a lot has happened since then. So there was definitely a need in light of the constitution for us to come up with sort of a new act that reflected some of the principles and some of the rules that have been laid down in our constitution. So, this is a long time coming that the Act, I think the first draft was published in 2009. So there's been various iterations of it. But the real purpose of it really was to bring this concept of expropriation in line with the Constitution. Now, Section 25 of our Constitution, which is the sort of very talked about property clause, obviously on the one hand protects private property and the right to private property. But on the other hand, it also makes provision for expropriation. Mm-hmm. And it sets out when expropriation can be allowed, either for a public purpose or in the public interest. And then it sets out sort of a couple of guidelines in respect of compensation that can be paid for purposes of expropriation. Now, I think that what's important to understand is that there's a couple of differences between the 1975 Act and the new Act that has come into well, it actually hasn't come into force yet, but it's been promulgated, that I just quickly want to go over.
Sure.
I think the first thing is that the old Act only made provision for expropriation for a public purpose,
okay.
Right? And it didn't include the framing of the Constitution, which also makes provision for expropriation in the public interest. Now, public purpose has historically been understood to mean, for example, expropriation for the building of a road, the building of a dam, that sort of thing where expropriating it would be for some kind of bigger public purpose. But the Constitution, when it was enacted, actually said that, apart from public purpose, we can also expropriate for public interest. And it provides some guidelines for what we regard as public interest. And the Constitution says that public interest can include the country's commitment to land reform. So even in the Constitution, there was always envisioned that expropriation could be a potential tool that could be used to achieve land reform, right? So the new Act expands the public purpose requirement to include public interest in line with the Constitution. So that's not controversial in any way because the Constitution already made provision for it. We are just now giving effect to it in the form of an Act. So that's the one, I think, important difference between the two. The second important difference, and we'll get a little bit into that as well, is the question of compensation. Sure. Now, under the old Act, compensation was made for provision was made for it in Section 12 of the old Act, where it specifically said that compensation was what you would get for the property on the open market. So, and from a willing seller, right? So the concept of sort of willing seller, willing, buyer, yes. That which we hear quite a lot of in land reform circles, that was kind of the framing of how expropriation would have worked under the old Act, sure. Right? So, and you were very likely to get a market-related price because that was the guidance in respect of compensation. The Constitution changed that, and again, as I say, I think a lot of controversy arises now, but what a lot of people don't understand is that the Constitution already made provision for a lot of these changes, 30 years ago. And the Constitution says that you must be compensated, but the compensation is not what you would get for it in the open market. The compensation is what is just and equitable. Yeah. So it changed the sort of, I would almost say, the benchmark that one uses to evaluate the question of compensation. So that was the second sort of main difference, and we'll get into the compensation discussion, I think, a little bit later. And then I think the third thing that's important to note is that it introduced quite a lot of administrative burdens on the state, which was not part of the old Act. The old Act was actually quite light on the procedure that had to be followed. You had to give notice, and then there was an opportunity for the owner to kind of respond to the notice. But ultimately, there wasn't a very defined procedure for how that process would work. The new Act is actually very, very procedure intensive for the state. And I would venture as far as to say, from a procedural perspective, I think the new Act makes it more difficult for the state to expropriate land, just given the laborious procedure that it has to follow than what the old Act did. I mean, for example, you've got to give notice to expropriate. You've got to engage with everyone who has registered and unregistered rights on the land. There's a duty to engage with various departments, like the Department of Environmental Affairs. You've got to engage with water and sanitation. And then there is also a duty to mediate if you can't, for example, come to a discussion on compensation. You can't get agreement on that. There's a duty to mediate. There's a possible duty to arbitrate. And then there is also the possibility of referring it to court. None of those things were provided for under the old Act. Okay. So I think from a procedural perspective, the new Act is a lot more laborious for the state and will actually, I think, ultimately make it a lot more difficult for the state to expropriate than under the old Act.
Sure.
Yeah.
So, yeah, I mean, I think that's really important that you mentioned that, because I think a lot of the rhetoric that's been out there is that this just gives the government unchecked power to do whatever they want with anyone's land.
Yeah.
So I think it's really important that at the top that we just cut that off at the knees.
Yeah.
I think the other thing that you mentioned, about public interest, I think it's really important that we highlight that, because I think, and I'm just thinking in terms of like time periods here, 1975, you were thinking that the government were only really sort of using the public purpose thing for a specific part of the population. Yeah. Obviously, post the Constitution and the enactment of the Constitution, we're now talking about the entire South African population. Specifically, the large majority of black families that don't have land or had their land stolen from them. And so the idea behind land reform is to sort of help them get their land back in many different forms. And obviously the Expropriation Act is supposed to allow that, which is what the Constitution said that we were going to do in Section 25 anyway.
Yeah.
And I think it's really important that from that we sort of, and we'll get into the sort of the racial issue later, but we kind of caveat that now and say that I think that's where people are getting a lot heated about this issue. But I think the point is that it's like we're restoring a sort of historical injustice. And it is in the interest of, at least the majority of South Africans that we do, prioritize that or at least allow for it.
Yeah, sorry, just to add on to that. I think that there's also this perspective out there that expropriation, and especially expropriation without compensation, which we'll talk about a little bit later, is somehow now going to be like the silver bullet to land reform, and it's going to give land back into the hands of black people and people who were previously dispossessed of land. Expropriation, and I think people must understand what it does. It's a tool that the government could potentially use in certain instances to expropriate land, right? But there are many other pieces of legislation in the land reform sector that provides for similar steps. If you think about the Restitution Act, if you think about, there's redistribution policies out there that also allow for this. Expropriation can be a tool to achieve those purposes, but it by no stretch of the imagination is the only thing that government can do. And I think that there's also vast tracts of like unused state land that could be made available for land reform purposes, which wouldn't require any sort of expropriation. So I think that if government views this as a thing that is going to achieve land reform, I think that's probably overstating what you can do with this piece of legislation, not only in its current form, but I think also just for what expropriation has been previously used for. And we've seen that the other forms of land reform, the other sort of mechanisms that exist, have been used with varying degrees of success, and unfortunately a lack of success in many instances. So just because you've got another tool doesn't necessarily mean you're going to effectively be able to use it, right? And I think that's also important to understand that this thing functions within a much broader legislative framework to achieve land reform.
And I think it's really important that you mentioned that. I was going to say it as well, but thank you for saying it. I think that, what did you say, 30 years since the enactment of the Constitution, and we're still sitting with a large majority of the population that haven't, received their land back or have, formal land rights to the land that they live on currently.
Yeah.
But anyway, I just want to clarify, and this is for all those, that are listening now. The Act does not say this is a law that will allow government to steal land and homes from white farmers.
I haven't seen that myself, no. Okay. It doesn't say that anywhere. I think even if a piece of legislation said that, it would probably be slightly problematic in our constitutional democracy.
I don't think it would pass constitutional muster.
No.
Okay, so let's get to the real reason that we're here. Because we all read like a whole bunch of nonsense online that doesn't exclude I mean, that doesn't just include the conversation for today. I mean, there's a lot of disinformation and hate speech out online. But you're an expert in this field of law. I'm learning to become an expert in this field of law. So let's play a little game of myth busting. What I'm going to do is I'm going to read to you a bunch of, headlines or tweets that have come out from a certain sect of society here in South Africa, but also a particular bunch of very famous and well-known people in the United States of America. We'll get there just now. And you're going to effectively be our mythbuster. You're going to tell us, is this disinformation? Is this incorrect? Why is it incorrect? So let's get into it. So statement 1. It's from the 10th of February, 2025. It was an article written by Flip Buys, the chairperson of Solidarity Movement. I'm not going to read the whole article because we don't have that much time, and I think it'll be quite boring. But I do want to highlight 2 statements in Buys' article. We differ with the ANC about the direction of the country. The many race laws that make us second-class citizens, their treatment of the Afrikaans community with the Bella Act, laws like the Expropriation Act, and the blatant threats made by certain politicians towards Afrikaners. That's statement 1. Statement 2. Ordinary South Africans should not bear the cost of diplomatic disputes and the ANC's reckless policies. Our loyalty to the country is as steadfast as our legitimate pursuit of cultural freedom and the abolition of the racial discrimination against us. So, end of statement. First things first, let's talk about this idea of race laws in South Africa that are discriminating against white farmers. Does the Expropriation Act and maybe a little bit less so, but does the Bella Act make Afrikaans persons second-class citizens?
I mean, I think that you'd be hard-pressed to find that in the wording of any of those acts. The acts themselves, both Bella and the Expropriation Act, make no reference to race whatsoever. And of course, we know that under our constitution, unfair discrimination based on racial grounds is not allowed. It has to pass, whatever law you have has to pass some kind of constitutional muster. So I think it's difficult to understand sort of the veracity of those statements when specifically looking at the Expropriation and the Bella Act. I think with Bella especially, a lot of the anxiety comes from this idea that Bella is an attack on sort of Afrikaans schools and Afrikaans only schools. And what's interesting about Bella from sort of a legal perspective, of course, is that Bella is not in any way something new in a sense, because it is giving effect to what has been a lot of kind of not legislative, but judicial developments in our law since sort of about 2007. So since about 2007, we've seen quite a lot of litigation around the powers of school governing bodies. What is the relationship between a governing body and the department? And all of those cases were pretty clear that while the governing body holds powers to, for example, set language policies or admission policies, the state ultimately is the final decision maker. And there was always under the South African Schools Act the possibility of the HOD in a particular province recalling the power of a governing body to make certain to do its admission policy or to make its own language policies. So Bella, in a sense, much like the Expropriation Act, kind of just legislates, I think, what has already been developments that we've seen come out of the courts. And to, I think, term it as a mechanism that is going to necessarily, suppress the Afrikaans language or suppress Afrikaner people in the context of expropriation, I think that's a complete overstatement of what these acts can do and what their intended purpose is.
And I think let's also just talk a little bit about like the Constitution in general, right? One of the biggest motivations by drafting a Constitution in the way that they did with this sort of the Bill of Rights as the forefront of this doctrine is this idea of apartheid, right? And the racial discrimination that came out of it, especially through law during the apartheid regime. And so it seems kind of bizarre to me to suggest that any kind of legislation coming out of the words of the Constitution itself would impose something that's like at the forefront of this document, right? So we're talking about racial discrimination. I mean, there is the equality section. which, I mean, effectively says that no one may be discriminated against based on, a variety of topics, including race. So just again, does the Expropriation Act impose racial discrimination?
No, it really doesn't. I mean, like I said, it's a piece of legislation that gives effect to the Constitution, and it must always be in compliance with the Constitution. And I'm sure we'll see court cases that test that. But I think that it certainly, on the face of it, does not have that intention. In fact, I think what it seeks to do is it seeks to redress, I think, some of the injustices of the past. But I think in a way that still balances the interests of the current. And I think that's important to remember, is that that it protects both property rights, which in South Africa, unfortunately, is owned mostly by white people, but then balances that with, with this need to redress some of the injustices of our past.
So sorry, Mr. Buys, your article is a myth. It poses disinformation about the Expropriation Act. So I think, Statement 1, myth busted.
Well, I think, and I mean, I think that people have different ideological ideas about what these things do. And if that's their ideological idea, it might be, I think it's based in misinformation and it's spreading misinformation. But that's clearly how they view it.
Okay. Statement 2. So on the 18th of February, 2023, an MP of the Democratic Alliance, Lee Potgieter, tweeted this: "Land expropriation without compensation will have devastating effects on our country and economy. Act now and help stop the expropriation bill. Send your objections to this email address by 6 March 2023. I just want to note that obviously that this was quite some time ago, so it wasn't in this sort of hullabaloo that's happening now in 2025, but it was when this act, that's now an act, was in bill form. And she was obviously asking for people to make comments on it. But we said at the top that we would, get deeper into this conversation of without compensation. So can the government just take your land and give you nothing? Is that allowable in terms of this Expropriation Act?
I mean, fascinatingly enough, no. I think that, what has been quite unfortunate about this sort of Expropriation Act and the rhetoric around it is that it has been termed as like, it out there in the public. I think the impression has been created that that's what they can do, that they can simply come and, your apartment somewhere in Cape Town and decide, no, we want it and we can just take it and we don't have to pay you any compensation, right? And that's certainly by no stretch of the imagination how this bill is framed at all. And I think it's important for that just to kind of look at what the bill actually says about compensation. And the starting point of it is sort of Section 12 of the bill, which specifically deals with determination of the compensation that has to be paid. Now, what's really interesting about the sort of first part of the bill first part of Section 12 of the Act is that it's actually entirely a mirror image of what our Constitution already says, right? So the Constitution says that in determining compensation for expropriation, the benchmark that we use is what is just and equitable. Now, just and equitable will always be a determining factor that is determined based on the facts in front of you, right? We see just and equitable will be used, for example, in eviction matters, right? Where we say an eviction can only be allowed if it's just and equitable. And we've seen courts grapple with that concept quite a lot, but it's not an impossible concept to arrive at. Like, there's certain factors that will be stock standard that you'll have to take into account. And the Constitution and the mirror image of the Constitution is actually captured in Section 12, gives us some guidelines on what must be considered when we're determining what is just and equitable compensation in a case of expropriation, right? So one of the things that you have to look at, for example, is the current use of the property. We have to look at the history of the acquisition of the property, the market value of the property. And we've actually seen that very often in these cases, market value is the starting point. So they'll still use market value as a starting point, determine what that is, and then if there's other factors that could influence either market value up or down, then we've seen those factors be applied, right? But market value is but one of the considerations that must be taken into account in terms of the Constitution. And then if there's any kind of state investment in the property, that needs to be taken into account. And then, of course, also the purpose of the expropriation. So those are the guidelines that the Constitution sets out for us. I wouldn't suggest that it's a closed list, but I think it gives quite a good sort of list of factors that must be taken into account. And we see that mirrored in the Expropriation Act. So the Expropriation Act says compensation is the default position. You have to be compensated. The compensation has to be just and equitable. And when we determine what is just and equitable, these are some of the factors that we will take into account. That is the default position. I think most controversial part of the Act is Section 12, subsection 3, which makes provision for nil compensation to be paid in certain instances. Now, I want to say, it doesn't say nil compensation must be paid in these instances. It says it may be paid, right? So it remains almost, I would go as far as to say, the complete an anomaly in a sense, like if nil compensation should be paid. And what the Act does is it actually limits the circumstances under which nil compensation would be allowed. So it categorizes, it gives us 4 categories where it says in these instances, not nil compensation must be paid if these instances arise, nil compensation may be paid, right? And those are where the land is being used for speculative purposes. So where the owner owns the land, right? But he's not developing it. He's not using it to generate any income. He's not using it for any purpose whatsoever other than the appreciation in value of the property. Where an organ of state holds land, so where, for example, we often see that some of the SOEs, like Transnet and Eskom and them, they own large tracts of land which they're not using. And in Cape Town, I know a lot of the military bases, for example, there's large tracts of military land that lies unused. That's another example of where the state could expropriate the land from a state organ, The third sort of instance is where the land has effectively been abandoned by the owner. So, and this is it makes it very clear that it must be by no fault of the if it's by it must be by the fault of the owner. The owner must intentionally have abandoned the land. So we know who owns it, but the owner does not exert any control over the land. It's not being used for whatever purpose. There's no no interest in it. And then the fourth instance is obviously where the state has sort of invested quite a lot in the land, and the market value of the state's investment kind of outweighs the market value of the land itself, right? Now, I want to say one thing. That's a closed list. That's what the Act says, only in these instances. So if you are the owner of a piece of land that you are using, that you are farming on, that you are using for agricultural purposes, or that you are living in, or that you are using for whatever purpose, right? It's very unlikely that you are going to fall within any of these categories, right? So the idea of sort of working farms, working agricultural land, simply being expropriated with nil compensation, the Act does not provide for that. It's impossible under the current way in which the Act is framed, right? The Act, you wouldn't fall within one of these categories, so the Act will say you have to be compensated, just and equitable compensation, and, that's the default position. So this idea of nil compensation, I think, has been completely blown out of proportion, as if it applies to each and every tract of land and each and every piece of property in this country. It doesn't. It's very, very limited when expropriation with nil compensation is a possibility.
And I think that's really important because, now I know that my apartment isn't going to be taken away from me in Cape Town, right? But also I think, the categories of land that you were talking about in terms of what is allowable in for nil compensation kind of situations, I think for me, when I think about land expropriation, that seems like the kind of land that should be prioritized anyway, because it's land that's not being used. Yeah. And quite frankly, it's a lot of land that the government already has in their hands. And so they wouldn't even have to go through this whole expropriation process because they have it currently in their possession. Obviously, if with the military example, they would need to go through this procedure. Yeah. But that's neither here nor there. So Lee Potgieter's tweet.
Yeah,
I think that's pretty
bit rough. Yeah,
but I think it's also pretty obvious. It doesn't just allow SOMA and nil compensation. There are a whole range of situations in which that would be allowed. So, sorry, Lee, myth. Okay, so this is a statement by Gina or at Ginny DMM. It was tweeted on the 24th of January 2025. It's a tweet. I think this is an easy one for you, but you let me know. This expropriation bill is just another race-based communist law and the death knell for South Africa. Okay, so I don't really know what a death knell is, so I'm going to ask you to define that for me. But we've already established that the Act does not mention race, at least one bit. But let's talk about some other things here. Communist law, what is a death knell?
I just want to clarify, English is not my first language, so I'm not 100% sure what is meant by that. I think that, again, like I said, the Act itself makes no mention of race. And I think that's important to understand because, you know, in South Africa, I suspect, because of our racial discriminatory laws and the way in which land is held in South Africa, the majority of land is still in the ownership of white. It's still in white ownership. So there is, you know, if land were to be expropriated for land reform purposes, right, one would imagine that disproportionately, just because of the patterns in which land is held in South Africa, white people will be more affected perhaps than black people would be. But the Act itself makes no reference to that, which means that black people are actually, their land can also be expropriated for a public purpose or in the public interest if that is something that needs to happen, or if there's reasons for that particular, for it to happen in that way. And I think that, you know, one of the things that us as the LRC, I think, have been a little bit concerned about in respect of the Act, and I'll mention it here because I think that it kind of debunks a lot of the anxiety around it being something that targets white people. The Act, we know that in South Africa, only about 30% of land and rights in land that people hold are actually registered in the deeds office. Now, it's very easy if I have a title deed to be able to prove my ownership of land. I can say, if the government comes and says we want to expropriate, and they say who's the owner of this piece of land that we want to expropriate, if I am the registered title holder in the deeds office, I can bring my title deed and I can say, here I am, I'm Mr. So-and-so, this is my proof that I'm the owner, right? That's, for the majority of land that white people own in this country, that's how they hold it. They hold it through a title deed. Mm-hmm. The truth is that a lot of the rights that black people have in land are not held in title deed or registered really anywhere. We get unregistered rights in South Africa. So if you think about, if you've got communal areas in sort of the former homeland areas, a lot of those land are, people have rights in the land, but those rights aren't written up anywhere, right? So if land, for example, like that had to be expropriated, the Act makes provision for unregistered rights to be protected, but a person must prove an unregistered right. And I think that actually makes it harder for, if black people's land had to be expropriated, whose rights in the land are unregistered, in the sense that it's communal rights or it's customary rights or something of that nature, right? It does make it a lot harder for them to prove that they are the holder of that particular right. And we've seen a little bit of that play out. I mean, I can use an example, for example, the Shell litigation that LRC was involved in, where we opposed on behalf of the Wild Coast communities the exploration license that was granted to Shell on the Wild Coast. I mean, that case in so many ways actually illustrates the difficulty that one would have as a black person holding unregistered rights in this country. Because what happened there was, the license was granted without any kind of discussion or talk to the people who actually live on the land, because they didn't have registered rights. Their rights are customarily, their rights are informal, and it's not registered anywhere. So an exploration license was simply granted without any consideration of the impact that it might have on the local community. And I think that if anybody was in any danger from a race-based perspective to be disadvantaged by this Act, I would go as far as to say I think that the group we are most concerned about would be black people holding unregistered rights in land where they are not the registered owners. They might be at risk of struggling to engage with this Act and to prove the rights that they have. But as far as a death knell for South Africa and, you know, a race-based, I I don't think that that's exactly what this can do. No, I think that's a bit overstated.
And I think like it's important that you mention, so the Shell litigation and the communities that we represent in that case, but also a variety of other communities that we represent here at the LRC. Most of them are holding on to this idea of unregistered rights, and I think that that's like you said, it's our primary concern, because the burden of proof is on them. So in the Shell litigation and in other cases that we're managing, this community had to come to us or go up themselves and say, hello, I live here, this is my land, what you're doing here, if it's mining, if it's like offshore drilling, this is going to affect me, it's going to affect my livelihood. And I think what you're saying is so important, because it's when we're thinking about land reform or land redistribution or whatever it is in this field, we need to be thinking about the impact on them and how we can, upgrade their rights so that these kind of situations don't happen, where suddenly now, the government can use this act to expropriate their land and not necessarily have to go through the long list of procedural elements because of the, complicated history of land and apartheid.
Yeah, because, if the state would show up and say, we want to expropriate a piece of land because we want to use it, for something, whatever, it's very hard. Purpose, it's very hard for people to, if their rights are unregistered and they're simply living there, to, like you say, you have to do a lot more to prove your right and to be almost entitled to some of the procedural protections that the Act makes provision for, which wouldn't be that difficult for people who own land that they own. You know,
they have this piece of document that says this is my land, whereas on the other side, other communities we represent, they don't really have anything.
They don't have anything. They have the knowledge and the customary rights. But to prove customary rights is also not written down, which makes it difficult. Yeah.
Okay, so I just want to get something off my chest. We're not going to die?
No, you're going to be fine.
Okay.
I think for the you might die from something else, but
yeah, at some point. But when I'm old, I'm happy with that.
Hopefully.
So, Gina, I'm sorry to say, but I'm quite grateful that your tweet is disinformation, because I don't want any death knells near me, whatever the hell that means. Okay, so we're going to pivot now to international media, because this became a bit of a crisis, not just here in South Africa, but overseas. So, statement number 4, Fox News headline, 24 January 2025. South African president signs controversial land seizure bill, eroding private property rights. So that's the headline. So this idea of land seizure, I hear this concept all the time, not necessarily just from Fox News. I think it's probably the first time I've heard it from Fox News, but a lot of political agents in South Africa also use this concept a lot. It's very evocative, it's very emotional, it gets people heated, it gets people in debates, and I think this concept, this phrase was used very specifically. So let's talk about it in terms of what it actually means and what the act actually says. Can it just seize land away from you, like you're at a police stop or something?
Yeah, no. I think that's the short answer. And I think we've seen this rhetoric. It's quite interesting, because we've seen it coming from the US, which and we've seen it on both sides of the political spectrum in some sense. We've seen it from sort of the Afrikaner white pressure groups like your Solidarity and your AfriForum, who have termed this as like a piece of legislation that is going to encourage land seizure. And then we've also seen it on the other side. We've seen sort of the EFF kind of also having this rhetoric about this act being able to be used for purposes of seizing land. And I think that it does none of those things. And I think that it's complete overstatement on both sides of the political spectrum about what this act could potentially do. And the act in itself does not allow for land seizures. I said at the start that, in fact, I think under this act, it makes it a lot harder for the state to seize land I don't even want to use that word because seizing implies something illegal, whereas expropriation, as we understand it, is a legal concept that has always existed in our law, exists in many countries in the world, and is a completely legal process. But the procedural safeguards that this act introduces, I think, makes it so much harder for the state to actually expropriate than, and the concept that they would simply be able to seize land using this act is completely wrong. They can't do it. Like, from a procedural perspective, it's not possible. And also, if you think about what the purpose is of expropriation, the seizing of land certainly does not fall within that concept.
And you said something about how a lot of countries in the world have a similar power, or their governments have a similar power. I'm not an expert in American law. I'm not sure if you are, but I think, and some interns in our office were talking about this the other day, about this concept of, I think it's called eminent domain.
Yeah.
And I think it's got a similar sort of, purpose to what expropriation is supposed to allow. And so I think it's kind of funny that, we're getting criticism from an American news organization that's in support of the current government that maybe has exactly the same power.
I mean, the American law does allow for it. It's, I actually, before this podcast, went and had a look, and yes, they do. They can also expropriate. I think the difference where the impasse lies for them is that they expropriate. They expropriate for public purpose, like we used to, and they don't have this kind of concept of the public interest, which our constitution obviously talks about as land reform being one of those. And I think that's where the impasse lies. But no, the American government has the same powers to expropriate if they wanted to, for the public purpose.
But they're not interested in the public. Sorry, that was lame. Property rights eroded was another thing that was mentioned in this headline. Have we lost our rights to our land?
No.
Because of this act?
So it's such an interesting kind of statement, because I think that like I said, this act in many ways reflects a compromise that was reached 30 years ago when we enacted the Constitution. And we know that at the time there was a compromise between private property rights, which needed to be protected, which I think was something that the old National Party government was very, very strongly in favor of. And then, of course, this need for land reform. And that's how Section 25 is framed. It protects the right to property, but it also recognizes that in no country in the world is property rights absolute, right? You can't have that, because sometimes you need to take property for a particular purpose, right? So our property rights are as they were under the Constitution and as they have always been. The Act just gives effect, I think, in a little bit more, gives a procedural procedural framework, I suppose, for enacting what we've already seen in our Constitution. And property rights, private property rights, are they're almost absolute in many ways. They shouldn't necessarily be, but in South Africa and in many parts of the world, they are regarded as that. But the Constitution doesn't envision it like that. It envisions it as you have property rights, but we also recognize it cannot be absolute, and we do have Section 25 does make provision for it to be taken away in certain instances. But it's not, like I say, a blanket taking away. There has to be a just and constitutional and legislative procedure that follows that process.
And I think what's important there is, so we have Section 36 as well, which is talking about this limitation statute, right? And a lot of Bill of Rights are subject to this.
Yeah.
And I think what's important to just point out is, I think in terms of all of those rights, I think property rights is probably the most protected against Section 36 than most of the other rights. And so I think it's actually harder and this is I think what this act does and what Section 25 does in the first place, is actually sets out that procedure for everyone to see.
Yeah.
And so it's not as simply as just sort of like, okay, but your rights are limited, so we can take it away.
Yeah.
That's not going to happen.
No, definitely not.
So Fox News, I don't like what you do, but I don't have any control over what happens in America. But I can say, leave us alone. This is a myth. Okay, so we're going to stay with America now. We're going to statement number 5. It's an executive order signed by Donald Trump, President Donald Trump, on 7th of February 2025. addressing the egregious actions of the Republic of South Africa. I mean, good Lord. He said, and I quote, "In shocking disregard of its citizens' rights, the Republic of South Africa recently enacted the Expropriation Act 13 of 2024 to enable the government of South Africa to seize ethnic minority Afrikaners' agricultural property without compensation." Okay, one more time, Cecile. Does this act in any way, shape, or form provide for racial discrimination or marginalization?
No, it doesn't. I mean, I actually, I searched for it. I tried to see if it in any way refers to anyone's race, and it really doesn't. And I think that, Donald Trump, I'm not sure, as lawyers, we often think that we make decisions, or one would imagine executive orders would be, issued on the basis of facts and rationale and research and, information that is available to them. But apparently it's not. So, yeah, there we go.
Okay, so I think we've said enough about that specific topic, but he also says two other things. And the one is that this act disregards citizens' rights.
I think, as I've said before, I think that the act tries to give effect to the rights of a lot of citizens in South Africa who were previously disadvantaged by by the history of South Africa. But I think that given its procedural safeguards, given its limitation on how compensation must be determined, and in the cases in which nil compensation is allowed, I think it very, very much protects the rights and the interests of property holders in South Africa as well. I think it's a very good balance between the two. So I think that's a complete overstatement. And I mean, I also think the idea of, citizens, I always worry when people say that, because I'm like, are black people and are people who not citizens, is that what about their rights? How are we thinking about the rights of everyone in South Africa? We are a country that have a lot of people, and we have to consider everyone's interests. And I certainly don't think that this act does what they think it does.
And I think the word that you use there, everyone, is really important, because I think in very limited circumstances does our constitution actually use the word citizens. And in most instances, especially the wider reaching rights, they speak about everyone. And that is like a really important concept that I think a lot of us South Africans are very proud of. And then kind of speaking about marginalized groups, he also mentions that Afrikaner agricultural property is going to be, taken away. We've spoken enough about that already, but I do want to ask a specific question about this idea. Does this act only envision farmland?
No, it doesn't. It's actually, it envisions all property, which, and I should clarify, it envisions all property, which means it's urban property, rural property, agricultural, non-agricultural property. So no, it doesn't differentiate about at all between the types of land that we are talking about. The only differentiation that does exist is that nil compensation, the provision when nil compensation is allowed, and those specific categories where it is allowed, that only applies to land, not to any other type of property. So no, it doesn't have any reference to that. And I suspect that the notion that it is aimed at Afrikaner agricultural land, probably comes from some of the pressure groups that seems to have influenced Trump's thinking on this issue. But also, I mean, because it is so broad, it actually includes anyone's agricultural land. So there's a lot of black people that own agricultural land in South Africa as well, either through their own efforts or because of land reform efforts or whatever it is that placed property in the land in their hands, and that land would also be subject to the Expropriation Act. So no.
And if I was listening to you properly, the way I understood it is that it's not about the type of land. This act doesn't deal with type of land. It's about the use of that land or the lack thereof.
Yes,
and that's absolutely. I think that's the main differentiating factor.
It might be that, for example, we're sitting in Cape Town today. I mean, it might be that they need to expropriate a block of
parking
flats
lots outside
or
the
a parking lot,
Parliament.
outside of Parliament, because they've got to build a road there, and the Expropriation Act would cover that instance as well. It's not a piece of legislation that is unique to farmland.
Yeah, I mean, social housing is a big issue here in Cape Town, so maybe it would help.
Yep.
Okay, so same statement, different part. So we're still talking about Donald Trump and his executive order. He says we'll stop receiving funding from the US because of this act, and also because, and I quote, "The Expropriation Act follows countless government policies designed to dismantle equal opportunity in employment, education, and business, and hateful rhetoric and government actions fueling disproportionate violence against racially disfavored landowners." Okay, there's a lot to unpack there. We've covered a lot of what was said in there already, but I want to kind of talk to this trend, not just in the US, but also among those actors that you were mentioning earlier within South Africa, about this idea of equal opportunity in all spheres of life in South Africa. Is that the purpose of this Expropriation Act, as well as any sort of affirmative action, BEE kind of laws in South Africa? Is it trying to dismantle equal opportunity?
No, I think if anything, it's probably trying to create equal opportunity. But I also think that, I mean, we know that the Constitution itself makes provision for affirmative action to exist, as it does for the Expropriation Act to exist, as it does for, BELA to exist in many ways. And all of these pieces of legislation, I think it's important the role that our courts play in this country. I think the judiciary is one of the last vestiges of real respect and really trying to make sure that what exists in our country is fair and is constitutional and those sorts of things. And we've seen a lot of these legislative provisions, especially around affirmative action, actually be tested through the courts. And sometimes the state's policies and legislation have won, and sometimes it hasn't. And I think it's important that courts grapple with these questions, that we make sure that what we have is something that gives effect to the sort of the ideals and the provisions of the Constitution, right? But I think that the idea that it is dismantling some kind of equality, I think is probably completely overstated. I think a lot of it is actually designed to kind of, create a more equal society. I also want to say that I'm not a political scientist, so I don't profess to know what the politics are behind Donald Trump's thinking and so on. But if one reads that executive order, it also, it cites sort of, his displeasure, I suppose, with South Africa's racially discriminatory laws and all of these sorts of things. But it also makes provision to, it also refers very strongly to the ICJ case. So South Africa's case with, where we're trying to sort of get Israel to comply with under the Genocide Convention. And then it also refers to South Africa tightening its relations with Iran. And I do wonder if that executive order is really about the Expropriation Act and whether there's not a different sort of underlying political reason for it, because it doesn't limit it to that if you read the whole executive order. So I think that it's a convenient excuse. I'm not sure if that was the real thinking, if that was the real reason behind it.
And I think it's interesting because last week I think I heard that Mr. President Cyril Ramaphosa was actually even on the phone with Mr. Donald Trump, or President Donald Trump, sorry, I did it twice now, President Donald Trump, talking about the sort of whole Russia-Ukraine issue again. So it doesn't seem like he's super angry with us. It just seems like it was maybe a knee-jerk reaction to the current thing that was on his desk.
Yeah, it's so hard with him to, like I say, to understand whether any of his decisions are rational and vested in any kind of research or understanding of the world, or whether it is a knee-jerk reaction. I think that there's a lot of people out there who are trying to find sort of rhyme and reason in the decisions that he makes, and I think that maybe that's not what we should be doing, and we should just accept it as sometimes a man becomes the president of the US and he makes decisions the way he wants to, and that's what we've got now, I think.
So the last part of that statement is this idea of disproportionate violence against racially disfavored landowners. And he speaks a lot about hateful rhetoric. Now, I initially was going to ask this question a little bit differently, so excuse me if I'm putting you off guard, but I kind of want to talk about the concept of rhetoric for a second, because it doesn't necessarily say that we've established that our law cannot racially discriminate. But it is interesting when you think about this conversation we were having earlier about, informal land right holders and hateful rhetoric coming out of even our own government officials' mouths. So I think about the way migrants are treated in South Africa. I think about the way that this act and a lack of land redistribution and land reform has been realized for informal land right holders. So I don't think that Donald Trump is right here, but he does touch an interesting sort of political and philosophical debate that we're having here in South Africa about this idea that, we have these great laws, but are they actually, protecting the most vulnerable, the ones that need it? So I want to kind of like almost delete the landowner's sentiment from that statement and kind of speak a little bit about like maybe he's touching on something here about, maybe we aren't protecting not landowners because they've got their rights and they're very well protected, but people that don't have, secure rights.
Yeah, no, I mean, listen, I'm not sure that's what he intended to say, but I do think that there is a real problem in South Africa around the way in which our land reform process has functioned up until now. I mean, the Commission for Restitution, which was meant to drive sort of the restitution claims, the historical restitution claims, we're 30 years along with that process, and at the current pace we're looking, it's unlikely that they'll be finished in quite a number of years, which is frustrating, right? And there's been sort of court cases where the LRC has gone to court and tried to get them to move things forward a bit quicker and get it all sorted out, and people are dying. Like the original claimants, a lot of them have passed away, and they haven't gained access to land that they were historically dispossessed from. So that is a big issue that people don't think about. The other really big issue is redistribution in our country. So land reform obviously has a number of legs, and the one is restitution, which is the historical claims, but redistribution, which is the second sort of leg, deals with this idea that we have to change the way in which land ownership is held in South Africa. And I said earlier that expropriation is but a tool in a toolbox, right? We have this idea of redistribution, which provision is made for in our constitution. But the way it's been implemented in practice has been so problematic, right? And so devastating to people who are trying to gain access to land by using these government policies and the redistribution process, that it's actually, I think, disenfranchised a lot of people more than it has helped them. I'll use a quick example. We're currently busy with litigation in the Beaufort West area, where we are representing 3 farmers who have benefited under the redistribution policy of the state, but when they applied for a 30-year lease over the land, which is one of the policies under which you could apply, to gain access to the land that they have successfully been farming. I mean, we don't often see a lot of success stories, and this is a success story. The government said, no, we're not going to grant you the lease. So there's currently litigation challenging that decision. But I mean, it's such a good example of, where with government's own actions, I think, in its own sort of warped way in which it applies its policies, have actually resulted in more disenfranchising of land right holders than what expropriation, I think, could potentially ever do to a person who's a title deed holder of land.
Thank you for that. And because I think it's really important that we reframe this conversation. Yeah. Let's get away from the fire and the death knells and the racial discrimination. And let's maybe actually racial discrimination should stay in the conversation, because that is what we're still trying to, the harms that we're still trying to restore here in South Africa. Sure. Okay. I'm exhausted. I think, let me just say, Mr. President Donald Trump, sorry, I just really didn't expect you to get elected twice. Myth. I need to go and have a sauna. I need to sweat out the impurities in my body. I feel like I need a full body cleanse, a massage, and maybe a run. How are you feeling? Are you still here with me?
Yeah, I think this is such an important conversation, because I think there's such a lot of misinformation out there, and the more it spreads and the more hysterics are created because of it. I think it's not good for the relations in the country, and I think that it's important to kind of clarify what is truth and what is myth and what is fiction, and what's just sometimes intentionally misrepresented, right?
Yeah. Exactly. So Cecile, everything that you mentioned off the top and the work that you're doing is like such a great inspiration to me and the candidate attorneys and interns that also work alongside us. So thank you so much for joining me today. You've been an absolute legend. I couldn't have done this without you. Actually, I know I could not have done this without you. But just at the top, I just wanted to say that misinformation, disinformation, hate speech, whether it's about the Expropriation Act or any other controversial topic, is rife online. And so we need to be really vigilant about the things that we're reading online, especially on a platform like X, where there doesn't seem to be any sort of regulation about what's posted online. So if you find yourself in a situation where you've become a victim of hate speech or a survivor of hate speech, or you feel like you've been misled by disinformation, please get in contact with us. We're really trying to, build this democratized big tech space here in South Africa. And we really want to make a change so that at least the way social media and other sort of media operates within South Africa, that there are some kind of standards when it comes to the online world. So people like Solidarity Movement and AfriForum can't just come along and just sort of mislead the public. And I'm only using them as an example because they were the main actors in this sort of Expropriation Act disinformation campaign. Cecile, thank you.
Pleasure. Nice to be here.
Thank you for tuning in to Legal Resources Radio. We hope you enjoyed today's episode and gained some valuable insights. If you did, or even if you didn't, please remember to subscribe, rate, and leave a review. Follow us on Twitter, Facebook, and Instagram at Legal Resources SA, or visit our website at lrc.org.za for updates and exclusive content on the incredible work our team is doing. We'll see you on the next episode of Legal Resources Radio. Stay curious, stay inspired, and keep up the good fight.